Good morning, sir. How are you?
Good morning. How are you? Good morning.
Good morning, viewers and listeners. Welcome. I extend my warm welcome to Mr. Sumit and Mr. Vaibhav Kulkarni of Ernst & Young India Limited. I extend my sincere thanks to our Chief Executive, Sri Atul Kumar Goyalji, and Deputy Chief Executive, Sri Gopal Bhagat Sahab, who has been instrumental in organizing this very important workshop. To set the tone, I will request our Chief Executive to please introduce the subject and set the context, please, sir. Thank you.
Thank you very much, Sharmaji. Very good morning to all. First of all, thank you to the team E&Y led by Mr. Sumit as well as Vaibhav also. And our DC also, DC Gopal Bhagatji and Mr. Sharmaji and all the HR person from the all the member bank, whether it private, because there is a gathering of all the men. So friends, as you are all aware, the government has changed this 29 law into the 4 codes basically, and we have taken a presentation from the E&Y. Initial presentation we have also taken, and then we have felt, moment we have taken the initial presentation, then we have felt there is a need to involve all the HR professional from all the banking side also, because there is a definitely change. So whatever I will tell you, whatever the initial we have understood from the E&Y, the government has already introduced the 4 labor codes, which already been effective from the November 25, and this was a consolidation of the 29 laws. The 4 code basically they are related to the first in the code on the basis of 2019. The another code in the industrialization code of the 2020, and the third is the occupational safety, health and working condition code 2020, and fourth is the code on the social security. So what we have initially understand from the our knowledge partner, basically this all 4 code has introduced by the government to improve the workers' welfare, whether it is related to the wages, whether it is related to the safety, whether it is related to the social security. And the first time, I think, in the law which we have seen the changes, the gig workers and the unorganized worker has also been included in this. And the working hours 8 to 12, it may be daily, but as far as weekly is concerned, there is a 48 hours maximum in this. The overtime, etc., which will be paid double, which was also there as on date also. The gratuity also, there is amendment in the gratuity also. Gratuity will be payable after the completion of the 1 year of the service also. And what we have understood in our initial understanding, there is a definition of the wages also. Some of the benefit that is very, very important for to understand by all the HR professional from the banking sector, because now what we are calculating the supervisor benefit on the basic. So they have changed the definition of the wages also. So maybe there may be some financial impact on account of the calculation once this already law has already been, code has already been introduced in from the November 25, already it has been come into the force also. Similarly, we have also seen there is a difference in the definition of the employee as well as the workers also. That is also need to understand who will be that is a employee, who will be treated as a worker also. So there is a lot of clarity is required from the E&Y. So this is my initial thought, and this is very essential for all the banking professionals also to understand what will be the impact either in the financial or other type also. So with this word, once again, I welcome all of you, and I place on record our sincere thanks to our knowledge partner E&Y for the 2 days conference. And feel free, my request to all the HR professional from the banking sector, if there is a need of clarity also, you can ask at the end of the presentation from the E&Y. So with this word, once again, welcome all of you.
Thank you, sir. Now I'll request Mr. Sumit Padia and Mr. Vaibhav Kulkarni to please carry forward this important session. Q&A session can be subsequently taken because if it all depends upon the number, sir. I think it is 130 plus, 130 plus. But you can respond to the queries subsequently, and we'll request now to please carry forward the session.
Sure.
In the text, yeah, in the text, I think the participants, if they feel, they can raise the queries in the form of text, and subsequently, if E&Y feels comfortable responding through text or through mail, they can get in touch with that. Thank you.
Sure.
Yeah.
Thank you so much, sir. First of all, we thank you and IBA to giving us this opportunity to conduct this workshop with all the member banks. We really appreciate it. We'll just give a quick background about myself and Vaibhav. So I am a director with the Financial Services Tax Practice with EY, been with the firm for more than 15 years. And across these years, I've handled diverse set of clients and financial services sector players, be it banks, brokers, AMCs, etc. Some of my core expertise lies in direct tax, corporate tax, international tax, and FATCA CRS. Today, as sir rightly mentioned, the agenda for the workshop is to deep dive into the new labor law codes which are there. And we have Vaibhav Kulkarni, again a colleague of mine who's a champion at this and been with the firm for long, who will deep dive into these laws and provide a brief overview in terms of what the law is all about, and then happy to take questions as and when it comes, and subsequently as well we can reach out and engage how we want to take this forward. So holding on the mic to you now to take this forward.
Sure. Thanks, Sumit. So what I've done is, just for representational purposes, I also have a presentation, which I will now share on my screen. And, the intention is to walk you through the presentation. Please let me know when all of you can see the screen. Somebody can ping me so that.
We can see the screen, Vaibhav, but it's
frozen. Is it?
No, it's the screen is visible, but it's only half of the screen that is getting. Can we keep it in full mode?
Is this better? Is this better now?
Now I think it's better.
Yes.
It's okay. Now it's okay, I think. Yeah.
Okay. So, like explained by Goyalji, the 4 codes were launched with much fanfare in 2019 and 20. At this point of time, these were ratified by both houses of parliament and also given presidential assent. So these were active legislation 5 years back. But for every legislation to come into effect, it has to have a go-live date. That go-live date has now been announced as 21st of November 2025. So the codes are live as on 21st November 2025. Now, the codes were introduced with a twinfold objective. The first objective is simplification of compliance, which is necessary for ease of doing business and getting foreign investment into our country. And second is, providing social security for one and all. So the intention is to, have unorganized workers, get into the social security net, which is absolutely critical, and provides the concept of universal social security. So that was the second objective. And the third is, the codes have enabling provisions which will increase the participation of women in our workforce. So these 3 objectives are intended to be carried forward by the labor force, and India is at such a juncture by which it cannot or need not choose between these 3 objectives. It needs all the 3 objectives to run parallel to each other to succeed over the next 6-7 years. So that's a little bit on the objective and the genesis of the 4 codes. Now moving ahead, as Goyalji again touched upon, the code subsumed 29 central labor law legislations in our country. So the code on wages subsumes 4, the Equal Remuneration, Minimum Wages, Payment of Wages, and the Payment of Bonus Act. The key amongst them are Minimum Wages and Payment of Bonus Act. The code on Social Security, subsumes 9 legislations. Now, the code on Social Security there has been uh, a familiar debate over the last month where some are hailing this code on social security as revolutionary, but others are seeing it as consolidatory. But almost all are converging on one concern, that the code on social security would raise labor costs and reduce take home pay. Now, just like to mention that this concern is overstated and largely it is misplaced, because the code on social security should be judged not by isolated provisions but by its capacity to correct failures in India's social security system. What the ministry has tried to do is that it has aligned the code on social security with the United Nations SDG, which recognize social security as a fundamental right, safeguarding dignity against life's risks. So, crucially, the code's language of rights and affordability imposes a positive obligation on the state to design schemes that deliver benefits to employees. So, together, these provisions or enabling provisions lay the foundation for transforming Provident Fund from a narrow savings device into a contribution funded social insurance system. The code also abolishes schedule-based applicability of EPF Act, under which coverage depended on whether an establishment's activity appeared in certain prescribed lists. So entire sectors, like if I say, for example, railways, financial institutions like banks, etc., insurance companies, and state establishments were earlier excluded or mired in litigation under the earlier erstwhile regime. But under CSS, any establishment employing 20 or more persons will be covered irrespective of the activity, subject only to limited exclusions. And very importantly, these exclusions now operate at the employee level, not establishment level. So while employees covered under state social security schemes may be excluded, contract and other workers who are engaged by state departments become entitled. So I think the code on social security is a welcome change, and it has to be read in the context in which it has been designed. The important legislations which have been subsumed in the Code on Social Security are the EPF Act, the ESIC, the Payment of Gratuity, and the Maternity Benefit Act. The third code, which is the OSH, subsumes 13 legislations, the key amongst them being the Factories Act and the CLRA. And most of the provisions are, verbatim reproduced into the OSH code. So I think very enabling similar identical provisions. And then we have the Industrial Relations Code, which is the fourth code, which subsumes three legislations, the key amongst them being the Industrial Disputes Act. Okay, now that we have a gist of what the overview and what are the labor codes trying to achieve and which are the 29 labor laws which are being subsumed in the codes, let me now talk about what are the key changes which are promulgated under the labor codes. The first one is around simplification and ease of doing business. So I already touched upon that. There has been a reduction in the laws from 29 to only the 4 codes now. Earlier, there were different definitions which had to be read in different regulations for determining eligibility thresholds, for determining contribution percentages, etc. Now, under the 4 labor codes, we have certain common definitions, like the definition of wages, which cuts across all the 4 codes, which is a welcome move. It will simplify registration and simplify understanding of the statute. The codes also talk about a single unified registration and consolidated return for compliance. So, if you go through the codes, it's talk about one unified return for all the 4 code compliances, which is a very revolutionary kind of a move. Second, for CLRA, earlier when you used to enter into contract with contract vendors or third-party vendors, for each state, the vendor had to take a separate state license. Now, there will be a single license on a pan-India basis, which will be taken by the CLRA contractor, which again is a welcome move. It will speed up certain activities for which you require contract labor. So this is the first step around simplification and ease of doing business, which is also the primary objective of the labor codes. Second, and an employee-centric move, is anointing the thresholds for minimum wages. So the ministry has notified that they will come up with a universal floor wage, which will act as the philosopher, mentor, and guide for the states to decide their respective state thresholds for minimum wages, with the only rider for the state being that the minimum wage threshold which they fix cannot be lower than the universal floor wage, which is fixed by the central ministry. Now, this will lead to parity of benefits on a pan-India basis for the employees and the workers. Third is around increase in gratuity costs. So the courts have introduced a gratuity trigger for all fixed term employees. Fixed term employees are defined as employees who are engaged for a specified duration of time. So if these fixed term employees complete a period of 1 year of service, then there will be a gratuity trigger. It is important to note at this stage that fixed term employees is a separate category of working population, and they are not to be confused with on roll employees who are permanent employees for whom the service threshold continues to remain 5 years. It is only for fixed term employees where 1 year trigger will lead to incremental cost of gratuity for organization. So that's on the first incremental cost in terms of gratuity for fixed term. And second, now the foundation or the basis for computing retirement benefits will now shift from basic salary to wages everywhere. So since the wage definition, like I will explain later on, is a definition which is a omnibus kind of a definition, the number of wages may be slightly higher than what is basic salary. So again, since the base has increased, the contributions will increase, which will lead to incremental cost. So the third point on increase in gratuity cost is incremental cost for organizations, both in terms of gratuity for fixed term employees and the base threshold for computing gratuity changing from basic to wages. Then around PF. Now, for employee provident fund, typically organizations where the salary is monthly pay is more than 15,000, either there are three options. One is that they give a choice to the employee whether he or she wants to contribute to social security or not. If the individual says that I don't want to contribute, then fine, that is paid out as a special allowance and no PF contribution done. However, if the company policy is that the PF has to be mandatory, then again there are two options. Either you contribute at 12% on the basic exemption limit, which is 15,000, or you contribute at 12% on the basic salary. Now, irrespective of what methodology or modus operandi is being employed by banks at large, one important thing which is clarified and which everyone should be aware is that what is the mandatory contribution is only the 12% of 15,000. Even if your policy is suggesting for employees to do at 12% of basic, whatever you're contributing above 15,000 is voluntary contribution. So the codes have announced a grandfathering period of 1 year where organizations can continue with their existing PF policy. So if your PF policy is to do 12% of basic, then you can continue with that for a period of 1 year from the time the codes have gone live. So no incremental cost on PF for the first year. And then post the 1 year period, the ministry has notified that they will come up with a new PF scheme. And then, of course, the base will also change from basic salary to wages. So there will be an incremental cost post 1 year. So no incremental cost on PF for first year and then incremental cost on the second year onwards. That's on PF. Social security for all. So like I spoke about fixed term employment, the codes also talk about social security now being triggered for gig employees or gig workers. So let's say individuals working for Swiggy, Zomato, or let's say Uber. All of these are qualifying as gig workers, and they will be entitled to social security. There are contributions suggested to be done by such organization at 1% or 2% to get them into the social security net. From an HR standpoint, in terms of protection of employee benefits, the codes mandate issuance of appointment letter to all employees. Annual health checkup mandatory now for employees above 40 years of age. And if you have a worker population, then for workers above 45, annual health checkup is mandatory. So if as a bank, you do not have this policy already as part of your HR compensation framework, then this may be an incremental cost in terms of providing annual health checkup to employees. And then around safety committees, so this is important for organizations which are having 500 or more than 500 workers. The codes mandate constitution of a safety committee led by a safety officer. Moving forward, in terms of workforce model, I've spoken about fixed term employment where there will be gratuity trigger after 1 year. Since the CLRA, which is the Contract Labor Regulation Act, has been subsumed in the OSH, and like I mentioned earlier, there are identical provisions. I think it remains to be seen that how organizations and especially HR teams will do a cost benefit analysis between hiring, that is fixed term employees, or outsourcing, which is contract labor. Contract labor, as in the erstwhile law, are prohibited from being engaged in core activities, which are main activities of the organization. But they can work for other incidental or ancillary activities like canteen activities, or let's say security, or let's say transport activities and stuff like that. But for the core activities, contract labor should not be engaged. And now with the definition of wages being kicking in, it will also apply to the third party contractor who with whom the banks may have contractual relationship, and you may have a situation where the third party contractor comes up to you and requests you to renegotiate his contract on commercial terms, because this incremental cost, just like they apply to the banks, they will also apply to those third party contractors. So, and that's where a pause is required, and a cost benefit analysis needs to be undertaken by the HR team as to which activity they need to outsource and which activity they need to do in-house and hire individuals for those. So that's an important point coming out from the labor code. Emergence of new workforce model. Moving on, the ministry recognizes the power which women bring to the workforce, and recognizing the Nari Shakti. The codes talk about equal pay for equal work irrespective of gender. The codes mandate transport facilities and workplace conditions for women employees working in night shifts. Night shifts are different in different states, but let's say, for example, in certain states it may be 7 p.m. to 6 a.m. For certain states it may be 8 p.m. to 7 a.m. But the codes mandate transport facility irrespective across states. And also, a formal consent needs to be taken from the respective woman employee, whoever is working in night shift, prior to them working in the night shift. So I think these are very enabling provisions. They will, kind of up the ante in terms of having a woman in our workforce. Then moving on, in terms of industrial relations and reskilling, more applicable for establishment with large workers. The courts talk about constitution of a grievance redressal committee, a GRC, for organizations having 20 or more than 20 workers. Constitution of a worker reskilling fund. Now again, this is the third element of increase in cost, where organizations and establishments having worker population will have to contribute to a worker reskilling fund to the extent of 15 days wages of the retrenched or laid off worker. This contribution will have to be then remitted or credited to the worker reskilling fund, which will be set up under the aegis of the central ministry. And then the fund, after receiving this money from the requisite establishment or bank in this case, will then credit that amount to the bank account of the retrenched worker. Now, this will be very important, especially in banks where you have a lot of unions and workers, and due to the emergence of tech now in the banking and financial platforms, there may be a scenario at some point of time where you need to retrench or let workers go, and then over and above the retrenchment compensation which they are anyways entitled to under the law, you are now also be required to contribute to worker reskilling fund. So an incremental cost there. Relief to MSMEs, the courts have increased the threshold which were need of the industry. There has been an increase in the factory threshold from 10 to 20, contract labor from 20 to 50, and similarly standing orders applicability from 100 to 300. So I think these are welcome changes, long been the demand of the MSME sector. And around enforcement, over the last 5-6 years, I think technology has been the driver in most of the discussions which organizations planning their entire success model around technology. So the courts are also introducing a virtual regulator who is now going to be called as an inspector cum facilitator, and they will use practices like the random based inspection system, which means picking up certain transactions based on the reporting and filings done by organizations, and then deep diving into dubious or non-reasonable or non-genuine transactions, and then doing a scrutiny, whether partial or full, as the case may be, to then identify non-compliance. So it will be a virtual administrator which has worked as a charm, at least in taxation, where the tax, as well as in GST, where the tax and GST collections are through the roof right now. So I think similar process is looked at being implemented in the social security or labor laws going forward. And then again, a long-standing demand of the HR, payroll, and other fraternity for curtailing of the period of 7A audits under PF and ESI. So they have reduced and brought a 5-year limitation period for the authorities within which they need to close and complete these audits. So these are some of the key changes in the labor codes. I will pause for a minute here. If there are any questions, I will take it before I move to the next part. You can unmute and ask your question. If there are no questions, Goyalji, I can move on.
We can raise.
I think you can continue, Vaibhav. You can continue. So if there will be question later on also, so we will submit either to submit to you, then you can reply offline also.
Sure. Okay, sir. So I will move on. Please let me know when you can see my screen.
Yes, sir,
Okay.
we can see.
Sure. Thanks, Amit. Now, let us move from the key changes to the key impact areas, which are deeply influenced by those changes, and what organizations need to do and do on a priority basis to manage the implementation journey of the labor code. The first step is classification of the working population into employees and workers. So earlier, we used to use these terms very loosely. And of course, in the service sector, we had organizations saying that, we are in the service sector, so there are no workers here. That is only for factory and manufacturing setups. So we don't have any worker population. There are also concepts propounded earlier like white collar, blue collar, and even gray collar. But all that will now go away under the codes because they have spoken about a definition of employee and definition of worker. And this delineation is very important because the cost or incremental cost will kick in if individuals are qualifying as workers. I will talk a little bit on this definition as we go around. Second is around looking at the compensation structure. Since the four codes have a common definition of wages cutting across all of them, and wages is a comprehensive definition, like I explained earlier, there can be an incremental cost, and accordingly, to optimize social security to the maximum extent possible, the HR team in the organizations will need to look at rejigging their compensation. In the past, for any compensation structuring decision, tax used to be a driver and primary consideration for doing compensation structuring. But now, with the labor codes, uh, social security will also have to be an important driving enabler along with tax to support compensation restructuring exercise. So I think that's the second thing which organization needs to do pronto, which is relooking at their compensation structure. Third, and I've spoken about it, emergence of new hiring models or workforce hiring model where you compare between what you need to hire and what you need to outsource, and a cost benefit analysis around that, because this will also lead to impact on your cost. So these three steps, employee versus worker, compensation restructuring, and workforce model, impact the cost and have to be done pronto. Parallelly, other items like relooking at your HR policies, your payroll policies, and your health and safety policies to have them in alignment with the labor codes. So while most of the participants in this call would be having very robust HR, payroll, and health and safety policies already, the intention here is to just have a relook because the codes have certain provisions whether all of that is there, and if it is not there, then do a gap assessment and incorporate those changes as part of your policy so that you are in compliance with the labor code. So this is around HR, payroll, and health and safety policy. And then, of course, looking at your compliance obligations. So the codes talk about unified registration, unified registers, unified returns, payslip formats, appointment letter formats. So all of that now has to be in line with the code. So if you are, irrespective of whether you are doing payroll in-house, if you're doing it in-house, then you have an in-house team, then those team should follow all those formats. If your payroll is outsourced, then even though a third party vendor may be assisting you in that, the primary responsibility remains of the HR and the payroll team to see that the forms are appropriate in line with the labor codes. So that's around compliance. And then enforcement, I think if you're compliant, no problem in enforcement. The intention, when our policy team discussed with the central ministry and with the labor secretary, what we understand is that the ministry wants to impose only minor financial penalties, monetary fine if there has been non-compliance. The intention is not to put anybody behind bars. But yes, depending on the multitude of offenses and the gravity of the offense, there are also prosecution risk penalties which are highlighted in the code. But that's at a very later stage. I think if you are there till this point on simplification of compliance and you're doing compliance, then I think this may not trigger. So these are the key impact areas which organizations have to look at, looking at the changes in the
Well,
first. Yes, sorry, someone is
in fact,
asking.
I'll just try to raise a couple of queries there from our side, and hopefully it's going to have an impact, inform the viewers and listeners who are attending this webinar. Suppose if an employee resigns after 21st of November 2025, is it going to have an impact or bearing on the calculation or computation of the gratuity formula? Number one. Number two, how it's going to have an impact on the definition of wages for public sector banks, particularly in that perspective, we would like to understand, because many of the public sector HR teams will be participating in this webinar. So if you can focus on the impact in these two fields to begin with, I think there will be many queries from the participants thereafter.
Okay. So to answer your question, the codes have gone live from 21st November. And the definition of wages have also gone live from 21st of November. So if somebody resigns today on 26th of December, then gratuity will have to be paid on wages. How it will impact organization is that in the past, whatever provisioning or actuarial valuation has been done by the bank would have been done on basic. That base has to be changed to wages. So let's say your basic was, let's say, 50, and now your wages is 80. Then the 30 will be the incremental cost for organization. And it's a retrospective impact. So when you are closing your books for the quarter 3, quarter ended 31st December and quarter ended 31st March, then you need to provide for that impact.
A couple of queries related to this, the new definition of the wages. Is it going to have an impact on the retiring employees after 21st of November? Because you say that the special allowance has also got to be factored into the computation of the pension or the retirement benefit.
Definitely, sir. Definitely, sir. Because see, so on wages, I have not come to that, but since you asked that question, I'll touch upon that. the intention is to have this common definition of wages cutting across all the four codes, and that wages will now be the fulcrum or the center point for computation of all retirement benefits. Now, what are the retirement benefits typically? It is provident fund, gratuity, ESIC, leave encashment, overtime, and statutory bonus. These are the six major components of retirement benefits, which are earlier were under basic, with the exception of ESIC, which was on total gross wages. So everything will have an impact because it's an incremental cost. There is a question from Badri Prasad, which says that the codes have gone live from 21st November. 45 days. So Badri Prasad, 45 days. See, I think you're confusing with, the state rules. So as we all know, labor is a subject on the concurrent list of our Indian Constitution. So what does that mean? Is both the center and the state have the responsibility to announce and enact and implement legislation. Now, as on date, the center has come out with all the four draft rules. The states, some of the states have come up with all the rules draft. Some states have even notified their draft rules into final status. So let's say if the state of Arunachal Pradesh has final rules which are ready. The state of Gujarat has 3 rules which are ready. They are only pending is code on social security to be notified. So the 45-day window is for merely procedural provisions, where if you have a pan-India presence, then one state may have different, second state may have different. But that has nothing to do with the payment of gratuity, with the payment of PF, etc., which is coming from central legislation, which is the Code on Social Security, which is already laws on 21st November. So I think, Badri, I hope I answered your question, in terms of the 45-day window. Another question was gratuity payment to fixed term and permanent employees. I think I've explained this, that for fixed term, there will be a trigger after 1 year of service. For permanent employees, it is 5 years. So if you actually look at the law, it is for permanent employees 4 years and 180 days, or 4 years and 240 days. And similarly for fixed termers, it is 180 days and 240 days. Yeah. Then Sachin Arokar had a query that banks have received notices from ESIC, SPRE for registering under ESIC. Banks are not covered. So is there a change? Yes, I think the threshold now, banks will also need to get covered under the ESI. The threshold, if you have a, above a certain workforce, which I explained earlier. So I think this will trigger. So Sachin, I think the very fact that you have received the notice is pointing to the fact in that direction, that I think this pre-scheme is an interesting scheme. They are saying, what if you read this pre-scheme 2025, it says that if you register now, there is no penalty for non-compliance. So, and that scheme is open up to 31st December 25. So I think you should take that benefit and get it done, Sachin Arorkar. Then there is a question from Kalupur Bank, which says that explain definition of wages. So I have not come to that yet. Again, definition of wages from Utkar Small Finance Bank. Again, definition of wages. Badri has understood. And now in terms of, okay, this is again on ESI from Indian Overseas Bank, saying that whether staff of the banks. Okay, this is fine. I think this I've answered. There's just a question from Rajiv Pandey for gratuity. If any retired employee who is 60 plus years of age working as consultant is a fixed term employee and eligible for gratuity? Interesting question, Rajiv Pandey. So when you say that this individual is a consultant, what can you explain to me whether there is any non-compete clause signed with the consultant in the agreement? You can unmute yourself, Rajiv Pandey. Hello. I think Sharmaji, we have spoken about this question earlier, where I have explained that if the contractual understanding is a P2P arrangement, where it is a contract for service and not a contract of service, both in form and in substance, then the individual will qualify as a consultant and then the labor codes will not be applicable. But if there are clauses like non compete in the contractual understanding, the consultant arrangement is merely done to optimize taxes for the consultant because the taxes are at 10% and not at 30% in case of salary. The
Correct.
consultant is actually working as per the policies of the company or the organization where he's working. Then he is not a consultant, he is a disguised employee, and accordingly labor codes will apply and gratuity has to be paid to that disguised employee.
Disguised. Yes. I'm a disguised employee.
Ah,
Got it.
so you have to I mean, see, this is a chance. See, where they're focusing on compliance, sir, the short term pain for long term gain. So I think somewhere there is a opportunity, and this is a good thing, and I'm really serious
Yes.
that you can fix your legacy issues. अगर पहले कुछ सही नहीं हो रहा था तो अभी
Yes.
गोल्डन अपॉर्चुनिटी है कि हम अपने आप को सुधारें. तो मेरी बीवी मुझे बोलती रहती है हमेशा कि ये आपने किया, ये नहीं किया. So, how I try to improve myself. Similarly, from an organization perspective, today, if there are certain gaps, and that's why I said at the top of the discussion, sir, that all organizations will have to undertake a gap assessment, both on financial and non financial aspects, to come up with the right way of working going forward under the codes.
Vaibhavji, just one small query here. Is it also covered in code? No, that if wife is suggesting to improve, we have to improve. No.
सर, वाइफ तो जगत जननी होती है, तो कोड में नहीं भी होगा तो समझ जाने का.
Maybe I just wanted to clarify. It is there,
जगत जननी होती है वो, is above the code.
So it's right time to mend your ways then.
Definitely. I mean, that's the
Yeah.
intention.
Please.
Another question was from again Kallupur Bank. So I think Rajiv Pandey has understood. He's saying it's a fixed term contract. So I think Rajiv, you need to look at whether the nature, the substance over form. Kallupur Bank is saying, can apprentices be paid gratuity? I think to see the apprentice contract, apprentice is not intended to be covered, but again, I need to see that contract. Somebody Utkarsh is asking is if an employee resigned and exited on 21st November, then employee gratuity will get calculated on basic or wages. I think we have advised this on wages going forward. Can we, Nainesh Jain asking a question on can we do changes during annual increment once statewide flows are clear? So I think the changes, Nainesh, can be done anytime. Typically, the experience has been that organizations do it at the start of the financial year or at part of the increment cycle because then the effect is not that much. You can kind of suppress that effect. So that's the intention of doing it, but you can do the changes anytime. I think no period as such. And Anthony, I think he's asking for a definition of fixed term employees. I think fixed term, so I explained that engage for a fixed duration of time. I think again substance over form, Anthony. So like for example, if I look at IT sector, let's say for example a company like Infosys, they may have a software engineer working for say a specific project for 1.5 year, and after the project is over, he or she leaves. So I think that is a fixed term employee. The intention to have it for a fixed term duration for a certain horizon, and then after that, a person goes away. That's what is a fixed term employee. Okay, I think right now there is so much only. I will move on. I've taken all the questions so far, Sharmaji, which have been asked. Yeah, I'm moving on for benefit of the group. Yeah.
Yes, sir.
Please let me know when you can see my screen.
Yes, we can see.
The employee versus worker categorization, I think the first step on the incremental cost. Codes define employee as an individual, irrespective of the role, level, nature, and salary threshold. So very omnibus or comprehensive kind of a definition of employee. And then the definition of worker given under the codes is borrowed from the definition of workman under the Industrial Dispute Act, covers manual, unskilled, skilled, technical, operational, clerical, or supervisory. But a worker excludes individual who's in a managerial or administrative role, also excludes an individual who's in a supervisory role with wage exceeding a certain threshold. So if you are in a managerial role, then you are an employee, not a worker. If you are in a supervisory role, meaning you are not only responsible for your own performance, but also for the responsible for the performance of your team, your division, your department, and your wages exceeding 18,000 a month, then again you are an employee, not a worker. But if you're an individual contributor with wages exceeding 18,000, you're merely following instructions. You are not, nobody is reporting to you. Then there is a chance that you may qualify as a worker and not an employee. And why this categorization is important? Because once you're a worker, then the following cost trigger, which is the impact written in this slide. One is overtime, which has to be paid now going forward at 2x the wages. Leave encashment. So the codes say that over and above 30 days, if there are any leaves accumulated for that worker, then he or she can encash it on an annual basis. So there will be a cash flow impact for the organization. Contract labor are also workers. So again, there will be parity, and if you have huge contract labor population, those will also be workers, and there will be an impact in the cost, and that's why you need to look at the hiring model. Administrative provisions around constitution of grievance redressal committee, and of course for retrenchment and layoff, as I explained earlier, incremental cost over and above retrenchment compensation of contribution to the worker reskilling fund. So I think again, the ministry is looking for organizations to do this classification on their own, while the intention is not to challenge them on the classification which they do. But yes, uh, you know, the codes are looking at replacing the EPF acts, that is the erstwhile acts, employer centric logic with a worker centric framework. So, while retaining familiar institutional forms, the code sheds PF's colonial legacy as a mere saving instrument and is looking at repositioning it as a tool of social justice. So, if there are any dubious classifications or categorization done, just you're having people as employees without a proper JD, job profile, a nature of the activity which he or she is undertaking, I think then it's but natural that the ministry will go after such establishments. So I think this is the first step on employee versus worker categorization, which organizations will need to do uh, going forward. Now around wages definition. So it's a big definition of wages under the codes. I have divided here into 4 limbs. The first limb talks about coverage. So wages covers all salary components expressed in terms of money or capable of being expressed. That's the first limb. Anything and everything is wages. Total remuneration is wages. Second limb is calling out exclusions from wages, so items which are expressly not wages. Items such as bonus payable under law, that is statutory bonus, conveyance allowance, HRA, overtime, commission, perquisites like housing accommodation, retirers like PF, gratuity, and any other service award by special order of the state government. All of these are called out as exclusions from wages, items which are not wages. Third limb is limiting the quantum of exclusions to a maximum of 50% of total revenue. Now, the ministry is quick to admit that there is, to prevent any misuse of the exclusion, the codes has introduced a uniform safeguard where excluded components which exceed 50% of total remuneration, the excess is added back to wage. So this closes the most exploited loophole under the EPF regime without distributing genuine variable pay or performance linked incentives, where the organizations used to contribute and break the components into various allowances to get away with a lower PF. So this is intended to plug that gap in the erstwhile EPF Act. So that's the third limb, the limiting the exclusions to 50% of total remuneration. And the last one is around remuneration in kind. They have said that remuneration in kind, to the extent it doesn't exceed 15% of total wages, will be added back in wages. Now, what is remuneration in kind is not yet specified. We expect some clarification to come in. But if you look at typically corporate sector, like say a bank, then remuneration of kind can be items like housing accommodation provided, or let's say you have a car benefit given to certain senior employees, or if you have stock options. I think all of that typically qualifies as remuneration in kind, but we will have to wait for the clarification to come in. So this is the definition of wages. Now, Let's try to explain this or understand this definition by a numerical example. Here, there is a case of Mr. A, whose total monthly remuneration is 50K, and I've broken it down into four components: basic, HRA, conveyance, and special. Now, there is no remuneration in kind here, so the fourth limb is not triggered of the definition which I explained earlier. So let's look at the first three limbs now. First limb, total remuneration is wages. Anything and everything is wages. So first step is 50,000, where I've mentioned the total remuneration. Third limb, second limb, identifying the exclusions. Exclusions from wages are HRA and conveyance, which is 18K. So I've written it down 18K. Step 3, limiting the quantum of exclusions to a maximum of 50% of total remuneration. 50% of total remuneration here is 25K, and my exclusions are 18, which are anyways lower. So 18 will be the exclusion. So wages for the purpose of the code will be 50 less 18, which is 32,000. And here you will understand that why the definition of wages is leading to incremental cost for organization, because so far all the retirement benefits, the contributions being made is on 20,000 in this example, which is basic. Now that base has moved from 20 to 32 in this example. Another example where I've kept the numbers the same, but I've just, and the components are also the same, but I've, tweaked the number for the exclusions so that the third limb of the definition comes into effect. So first limb remains the same, 50K. Second limb, exclusions now become 28. And now the third limb triggers where quantum of exclusions is 50% of remuneration, 25. Or 28, whichever is less, so 25. So the 3,000 are added back to wages. So wages for the purpose of the code is 50 less 25, which is 25, which is still higher than 20, but lower than 32 in my last example. So what do we understand from this? That there is a need. Why compensation restructure? To rejig the structure, to have certain components built in as exclusions if you don't already have them, to make the structure more social security friendly. Because in the second example where I had the same components, I tried to increase the quantum of these allowances, and it has led to a little reduction in my PF cost. Still incremental cost, but it's a reduction from the last example. So any HR teams, comp and bend teams, reward teams in the various banks has to look at this with particular interest and rejig their compensation so that it is more optimized from a social security perspective. Okay, so this was on wages. Coming back to my earlier slide, I think flexi hiring I've spoken about. And other items like HR, health and safety, all of these are more procedural. So I think not much to discuss around that. I think in terms of what are the changes there, more or less procedural. These are the 8 steps around go live. What organizations need to do if you've already not done this in your organization. I think look at these 8 steps and get alive and kicking, because these are the areas which the ministry is also looking for you to comply with. Employee versus worker, rejigging structure, analyzing the financial hit on P&L, looking at your hiring model, ring fencing your HR, payroll, and health and safety policies and processes, working on aspects of your employee relation, creating those skilling fund, and the meeting the compliance procedural provisions under the codes, and then of course having robust internal controls and creating a framework which will support you throughout the labor code lifecycle. So these are the critical 8 steps which organizations need to look at prior to going live. And since we have the HR folks in as part of this session today, these are the key impact points for HR. First is around shifting certain allowances will reduce take home but accordingly increase retirement corpus. So your reward strategy should address these concerns and communicate the benefit as to why this is being done, how this will benefit, etc. For performance link pay or incentive, while the law is silent and it does not exclude this item from wages expressly, uh, but if you are seeing the statements from the ministry and the labor secretary, I think they are looking at only covering regular earnings or regular payments coming in with regular consistent frequency as part of the wages. So performance link pay typically is a one-time payment. So the clarification is yet to be received, but I think it's more tilting towards the fact that the performance incentive would not fall under wages. So this is one point. Then of course annual health checkup, that will require a budget allocation and vendor tie-up if you already do not have this as part of your policy and ideology and culture. From an ESI perspective, you would be covered and there would be an expanded coverage. So I think somebody has asked the question earlier and the SPRE 2025, and I think you should look at that. Then, of course, for fixed term employees or FTEs, now they are a viable hiring model. So you should look at leveraging this flexibility and get this concept or principle of hiring versus outsourcing in most of your recruitment decisions from an HR standpoint. Again, prohibition on your core banking activity through contractor will involve review of your outsourcing arrangement with the third party vendor, plus the third party vendor may also come to you asking for changes or increments or renegotiating on the commercial terms of their contract. So that needs to be looked at by HR. And then focus on the standing orders for banks which have unions, multiple unions. I think you need to look at the IR code, look at the standing orders, look at constitutional grievance redressal committee, safety committee, to have the provisions in appropriate force. And then, of course, a proper communication plan and a reward structure which will explain to the employees, what is coming. This is the law. I think all of that has to be circulated. So I think lots of work. Since these are labor codes, most of the action will be expected from the HR, whether it is a corporate HR or strategy HR or comp and ben HR or operational HR. I think everybody has to pull in, and they have to work in tandem with the other teams in the organization like payroll, legal, and finance to see that the codes are implemented in the letter and spirit. And these are the next steps, immediate steps for all banks. Do a gap assessment or a financial impact assessment, looking at hit to the P&L and align the provisioning with the rules. Uh, Develop the reward restructuring roadmap, which is the compensation restructuring exercise, which I spoke about earlier. And then, of course, non-financial gap assessment, which is looking at your HR, payroll, and health and safety policies, including grievance handling. So these are the immediate steps over the next 1, 2, 3 months. As on date, there is a statement yesterday from the secretary that the codes will expected rules to the codes are expected by the second week of Jan. Then, as per the parliamentary procedure, they will be put up for public discourse for 45 days, and after that they will go live. So we have a period of 2 to 3 months for the other procedural provisions also to get standardized, and then they're expecting everything, parallelly to be done. So I think immediate steps which organizations need to take. I think that's all from my end. I think I will now wait for any other questions. I'll look at answering them, and then I will request Sharmaji to come. Okay, there's a question from Badri Prasad who would like to understand the difference between employee, workman, and worker. I will explain that. Another question is whether field staff in individual role in banks like sales executive would be considered employee, which category they would fall. So I think all of that will depend on what is the documentation which you have with them, what is the uh, what are the role they are doing, whether this sales executive is a purely a individual role, or does that also involve reporting or responsibility, multi responsibility, whether they are doing any admin role also over and above the selling activity which they are doing. So I think the profile will have to be seen, Badri Prasad. Manage,
Wherever one more
managerial or administrative cap. Sorry, somebody saying, yeah, Goyal ji, आप कुछ बोल रहे हैं. I'll mute.
Regarding ESIC also, because you are saying ESIC will also be applicable after a particular number. In banks, what we are doing instead of the ESI, basically we are taking the policy cover where we are providing the medical facility. So what is your view about that? Yeah, I want to little understand that. Mute. You are on mute.
You are on mute, sir.
Sorry. So I'm saying whatever contributions you are doing under the Banking Regulation Act, are they more benevolent in nature than the ESI? If the answer to that is yes, then you can continue with that, because even certain state legislations like the Shops and Establishments Act are not yet been repealed. They will continue to remain active. So tomorrow, if the state codes have certain provisions and shops and establishment has beneficial provisions, more beneficial provisions than the state code, then you have to harmonize and use the state code or the shop and establishment. So today, if you feel that जो आप कर रहे हैं अभी वो सही मायने में आप ज्यादा बेनिफिट्स दे रहे हैं under that as compared to ESIC, then continue with it. Otherwise, you will have to fall in line and get registered. That's the messaging. Yeah. Is that clear? Yeah. Okay.
Yeah. Okay.
Yeah. Thank you. Then question from Hani Sharma, who's asked that who will come under managerial and administrative. And I think here, since they have not defined it, I mean, I know this is a industry question, but let me try to decode it for you. So if I see, so I've looked at around 80 judgments in the labor law framework. And I will tell you some interesting judgments which have come through so that you are clear. First, a airline pilot. What do you think that person, he or she, will qualify as employee or worker for the aviation industry? I brought about aviation because it is in focus with Indigo right now. So, so if you look at airline industry, a pilot, he has been held to be a worker under the code. What the tribunal held, that he only drives the machine. He does an individual contributory role. He doesn't do any managerial role. He is not deciding any decision, strategy, nothing. He has nobody reporting to him. He is only flying the plane. Whatever instructions you get, so okay, from here to there you have to fly. He does that. There is no supervisory role. No, he doesn't. He does not do any administrative. He doesn't have to fill any form, nothing. कुछ नहीं करना है. He qualifies as a worker. Second, a software engineer in a reputed IT company was held to be a worker, not an employee, where that individual was able to prove with documentation his employment contract and also emails suggesting that he was an individual contributor. He merely followed instructions. Nobody reported to him. He didn't do any managerial role. He didn't do any admin role. He didn't even come to office. He worked remotely. So when he was fired or laid off, he demanded retrenchment compensation, and the court agreed with him and said, yes, he's a worker based on the documents. So, and another, from a bank perspective, the famous case of Vandana Joshi, where she took Standard Chartered to court and said she was a teller in a bank. And she said that I have been fired or laid off. I am a worker, not an employee. I also demand retrenchment. Now there, Stancy was able to prove with documentation that she has admin duties. She had supervisory role on certain other tellers. So she, as per the definition, was not a workman then. She was an employee. And the court held that she's an employee, not a worker, and is not entitled to retrenchment compensation. So I'm saying this is different for different people. I think what is important from a bank perspective is watertight documentation. The documentation should mirror the substance of the arrangement. What activity the person is doing should be clearly listed down in the job profile and the JD, so there is no ambiguity, and any regulator, when using their own independent mind and analysis, is able to, is visible without much fuss that which way the person is tilting. Okay. Special allowance. Badri has asked a question. Special allowance will be considered in inclusion. That's correct. It's not an exclusion because special allowance is a residual number. It is a regular earning. Every month you get the special allowance. So that will be considered in wages. Now, Amitabh Chatterjee has asked a question. If some outsourced activity provider is not complying with the labor code, then what is the bank obligation in this scenario? So for For third-party vendor, okay, if he or she doesn't comply with the labor code, then if there is any individual in legal employment with that third-party vendor, then that becomes a contract labor for the bank. And then if that entity doesn't do it, then the bank steps into the shoes of the principal employer, and the bank will have to do that obligation. Of course, there will be enabling indemnity provisions in the contract with the bank has with the third-party vendor to recover that amount back from the third-party vendor, but you will at least have to make the payment. So there is a no primary responsibility, but a secondary responsibility on the bank. Amita. Mr. A.K. Thomas has a question. Mandatory health checkup. I think the age limit for employees is 40, sir. For workers, it is 45. No confusion. Dheeraj Dhakke has asked a question. 50% wages or gross salary or CTC? Sorry, I didn't understand. But what you're trying to understand is what is the quantum of exclusion. So the court say that the quantum of exclusions can be a maximum of 50% of total remuneration, 50% of CTC. So it does not mean that if you make your basic salary to 50% of CTC, then you're good. It doesn't mean that. So that's for Dheeraj. Sudhanshu is saying, can this PPT will be shared to us? Definitely, why not? I will share it with all of you. Hani Sharma has asked a question whether one-time payments such as performance-linked incentive. I think I've explained that. The intention is not to look at one-time payments as coverage and wages. What the ministry is looking at is payments with regular frequency, consistency will be covered in wages. Badri Prasad asking another question. Rules are supposed to come by second week, so execution has to be done after that only, or we have to start execution immediately. You really want me to answer that question, Badri Prasad? I think execution has to start immediately. The codes have gone live from 21st. So you, as Sharma ji explained, that if somebody quits now, you cannot wait and give that person on basic, right? You have to give on wages. So I think the execution has to start immediately. I think it is, you have to start immediately. Whether any clarification on nature of work that can be outsourced, IR division from BOI, Bank of India, looks like. Whether any clarification on nature of work that can be outsourced, considering the non-recruitment of Safai, Karmachari and sub-staff. So nature of work, I think there is no clarification on nature of work. I think wherever you or an organization feels that for certain activities it requires contract labor, then you can have that. So I think that should not be a problem. Worker as per Delhi High Court, I don't know. This was deleted. Then Yogesh Asrani has asked a question. If we keep basic as 50%, will we be compliant? No, so I've answered that. You will not be compliant. It is not basic at 50% of CTC. It is exclusions restricted to 50% of total remuneration. Rajiv Pandey has a question. After 1 year from now, PF calculation to be done on wage. Yeah, that's correct. Correct understanding.
Vaibhav, should we do it differently? Because this way, I think this will continue to go on. I think anyone who
Yeah,
has questions
you
or
can
would
ask.
like to engage, we can reach out to IB and they can direct you to us, and then we can engage accordingly. Because else, we'll have different questions on this, and we'll not be able to answer all, frankly,
No, sure.
during the
I
short
think
span of time.
no, this is fine. I think if Sharma, I leave open the floor to Sharma ji and Goyal ji for their concluding comments on this. Yeah.
Sure.
Sumit ji, yeah, I think there is not going to be any end to the queries. There will be
Correct.
lots of questions going into the minds of the participants. So what we can do, we will internally discuss how to take it forward at the industry level, and we'll get in touch with you also subsequently, and we'll plan accordingly.
Absolutely, sir. Absolutely.
So, and there is going to be a huge impact on the way the HR computes the salary and wages, and it is going to have a bearing on the finances also. So there is a need to relook into, sit there and analyze what are going to be the impacts on the organization. So it's a very serious impact that is going to hit the industry in a month or two when the courts are going to go live subsequently. The organization should be in readiness to face the changes, the consequences thereafter. So the readiness is more important, and for that, as a proactive organization, IBA will definitely try to get engaged with the other stakeholders, other supporters, other consulting firms. We'll get in touch with you also how to take it forward with our chief executive and deputy chief executive, how to get it discussed at the highest level so that it percolates in a proper way down to the participant level.
Absolutely agree, sir. Absolutely agree. In fact, as you rightly pointed out, sir, the law is effective immediate. The impact is huge for all organizations. There is no exception. And it has fourfold implications, as Vaibhav and you guys said, right? One is on the structuring of the compensation, on safety, on policies, legal impact is also there. So it's a humongous effort that all organizations will have to undertake so that they are at the right side of this law.
No, very true. In fact, an Ostrich Act is not going to help us out. We'll have to bare our heads and bare ourselves and face the challenges. So we'll discuss subsequently. And I would like to just request our chief executive to just say the concluding remarks.
Thank you very much for our knowledge partner as in E&Y. Very nice presentation. At least it is a eye opener also, because as you have told rightly, it has the impact of the entire industry. Banking industry is not the exception of this. Definitely there will be a the implication of the financial also, and we have to be very compliant. This was the role of the IB. This is the reason why we have called you for the giving the presentation to all the HR professionals also, what we are required to do. So we have to very compliant as far as the new law is concerned. As already you are saying, it has already been come into force also. So definitely whatever Sarmaji has told, we will think how we will be in a position to help our all the member also. That we will decide how we have to engage. Then the role of the IBA. So there should not be need of the each and every question by the each and every bank also. They will send us, and then we will take the advice from the knowledge partner. Then we can suitably advise. So this is our plan also. So we are just thinking. So let us think. And once again, thank you to MMG as well as the Sumit also, and my thanks to all the HR team also from the different, because it was a very short notice, but it was the urgency also, because when we have seen their presentation also, the need was felt. There is a immediate needs. At least everybody should be prepared. So this was the purpose of the today's meeting. Once again, thank you to all the HR professionals as well as the knowledge partner E&Y. Yeah.
Thank you, Goyalji. Thank you again for this opportunity, and happy to help all the banks. I mean, wherever anybody needs any assistance, you can direct them to us also. Centrally, if we want to do it, we can do that way. Whichever way we can agree and move forward on this. But yeah,
Definitely.
one aspect which we are again repeating, the law is immediate, so everyone needs to action on it immediately. I think that's the critical takeaway from this session.
So thank you.
Thank you. This was the purpose of the today's meeting also. This was the only purpose. Okay.
Absolutely.
To
Thank you so
awaken
much.
the bankers, to awaken the bankers, awaken the stakeholders of the impending challenges that are going to be posed by the new codes. So that was the purpose, and I think you have rightly succeeded in stirring the entire harness nest that way. And we will take it forward for the benefit of the industry.
Definitely, sir.
In touch with you. Thanks
Definitely.
to both of you, Mr. Sumit ji and Vaibhav ji, and all the participants for actively participating in this program. Sir, thank you for giving us this opportunity. Many thanks, and wish you all the best for the new year. I wish you all a happy new year 2026.
Thank you. Thank you so much, sir, for this opportunity. Thank you, all the member banks. Really appreciate it. Happy New Year to everyone. Happy holidays.
Thank you. Okay.
Bye bye.
Bye.